Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in United States ex rel. Polansky v. Executive Health Resources Incorporated. In this case, the court considered this issue. Does the government have the authority to dismiss a False Claims Act lawsuit brought by an individual on behalf of the government if it initially declined to take over the case, and if so, what standard applies? The case was decided on June 16, 2023. The Supreme Court held that in a qui tam action filed under the False Claims Act, the United States may move to dismiss under 31 U.S.C. Section 3730C, 2A whenever it has intervened, whether during the seal period or later on. In assessing a motion to dismiss an FCA action over a relator's objection, district court should apply the rule generally governing voluntary dismissal of suits in ordinary civil litigation, Federal Rule of Civil Procedure 41A. Justice Elena Kagan authored the 8-1 majority opinion of the court. Section 3730C, 2A provides that the government may dismiss the action notwithstanding the objections of the relator, so long as the relator received notice and an opportunity for a hearing. Contrary to the government's contention in this case, this does not mean that the government may dismiss the action without ever intervening in the case. Neither the text or subparagraph, 2A, nor the broader context supports this understanding. But Polansky's contention, that the government may dismiss only if it intervenes during the seal period, also fails. Under Section 3730C, 3, the government can intervene either during the seal period or at a later date upon a showing of good cause. If the government successfully intervenes, then it becomes a party to the litigation with the attendant rights, including the right to dismiss. The Federal Rules of Civil Procedure are the default rules in civil litigation, and nothing warrants a departure from those rules here. Thus, in assessing a motion to dismiss an FCA action over a relator's objection, district court should apply the rule generally governing voluntary dismissal of suits in ordinary civil litigation, Rule 41A. Justice Brett Kavanaugh authored a concurring opinion, in which Justice Amy Coney Barrett joined, calling upon the court to consider, in an appropriate case, whether the qui tam device is inconsistent with Article 2 of the U.S. Constitution. Justice Clarence Thomas authored a dissenting opinion, arguing that the FCA does not permit the government to dismiss a qui tam action after it has declined to take over the action from the relator at the outset. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kagan delivered the opinion of the court. The False Claims Act, FCA, imposes civil liability on any person who presents false or fraudulent claims for payment to the federal government. The statute is unusual in authorizing private parties, known as relators, to sue on the government's behalf. When a relator files a complaint, the government gets an initial opportunity to intervene in the case. If the government does so, it takes the lead role. If not, that responsibility falls to the relator, the only person then pressing the suit. But even when that is so, the government retains certain rights, including the right to intervene later upon a showing of good cause. The questions presented here concern the government's ability to dismiss an FCA suit over a relator's objection. Everyone agrees that if the government intervenes at the suit's start, it can later move to dismiss. But the parties dispute whether or in what circumstances the same is true if the government declines its initial chance to intervene. And the parties disagree as well about the standard district court should use in deciding whether to grant a government motion to dismiss. Today we hold that the government may seek dismissal of an FCA action over a relator's objection, so long as it intervened sometime in the litigation, whether at the outset or afterward. We also hold that in handling such a motion, district court should apply the rule generally governing voluntary dismissal of suits, Federal Rule of Civil Procedure 41A. The FCA dates to the Civil War, when a congressional committee uncovered stupendous abuses in the sale of provisions and munitions to the War Department. Testimony before Congress painted a sordid picture of how the United States had been billed for non-existent or worthless goods, charged exorbitant prices for goods delivered, and generally robbed in purchasing the necessities of war. To put a stop to the plunder, and more generally, to protect the funds and property of the government, Congress enacted the FCA. The Act, then as now, imposed civil liability for many deceptive practices meant to appropriate government assets. From the start, the FCA has been enforced through a unique public-private scheme. Federal prosecutors may of course sue an alleged violator, all on their own. But private parties, again, relators, may also sue, in so-called qui tam actions. Those suits are brought in the name of the government, and the injury they assert is exclusively to the government. A qui tam suit, this court has explained, alleges both an injury to the government's sovereignty arising from violation of its laws, and an injury to its proprietary interest resulting from a fraud. But in one important sense, a qui tam suit is, as the statute puts it, for both the relator and the government. The FCA, we have explained, effects a partial assignment of the government's own damages claim. If the action leads to a recovery, the relator may receive up to 30% of the total. Because the relator is no ordinary civil plaintiff, he is immediately subject to special restrictions. He must file his complaint under seal, and serve both a copy and supporting material evidence on the government alone. The government then has 60 days, often extended for good cause, to decide whether to intervene and proceed with the action. If the government, during that so-called seal period, elects to intervene, the relator loses control. The action then shall be conducted by the government, though the relator can continue as a party in a secondary role. Only if the government passes on intervention does the relator have the right to conduct the action. And even then, the relator is not home free. The government, after all, is a real party in interest in a qui tam action. So Congress gave the government continuing rights in the action, not least the right to the lion's share of the recovery. Most relevant here, the government can intervene after the seal period ends, so long as it shows good cause to do so. The main issue here is whether the government, if it has declined to intervene during the seal period, retains yet another right, the right to dismiss a qui tam action over the relator's objection. The FCA gives the government unilateral authority to dismiss in at least some circumstances. Section 3730C, 2A, which we'll call subparagraph 2A for short, provides that the government may dismiss the action notwithstanding the objections of the relator, so long as the relator has received notice of the motion and an opportunity for a hearing. Nothing in the statute, however, expressly states whether, or when, that authority survives the government's decision to let the seal period lapse without intervening. The competing arguments on that score hinge significantly on surrounding provisions, more precisely, on how subparagraph 2A fits into the rest of Section 3730C. That subsection addresses the rights of the parties: the government, the relator, and more briefly, the defendant. It contains 4 relevant paragraphs, which we summarize in order. Those who believe in verification may refer to this opinion's appendix, which lays out all of Section 3730's relevant text. A helpful hint to start with: you might want to pay attention to what each paragraph says, or not, about when it applies. Paragraph 1 applies, as its first clause states, if the government proceeds with the action. In that event, the government shall have the primary responsibility for prosecuting the action, and shall not be bound by an act of the relator. The relator still can continue as a party, file motions, conduct discovery, and so forth, but only subject to the limitations set forth in paragraph 2. Paragraph 2 then spells out certain rights of the government. You have already seen subparagraph 2A, enabling the government to dismiss an action over the relator's objection, after notice and opportunity for a hearing. Subparagraph 2B is similar. It allows the government to settle an action notwithstanding the relator's objections, so long as the court finds after a hearing that the settlement is fair and reasonable. Finally, subparagraphs 2C and 2D allow the court to limit the relator's participation in the case, because, among other reasons, it would interfere with the government's prosecution of the case or cause the defendant undue burden. Next, paragraph 3 applies, as its first clause states, if the government elects not to proceed with the action. In that event, the relator shall have the right to conduct the action. But a caveat immediately follows. The government may intervene at a later date, i.e., after the seal period, upon a showing of good cause. And last, there is a caveat to that caveat. In granting a later intervention motion, the court may not limit the status and rights of the relator. Finally, paragraph 4 applies, as its first clause states, whether or not the government proceeds with the action. That provision enables the government to obtain a stay of the relator's discovery if it would interfere with the government's investigation or prosecution of a related legal matter. And so to recap, focusing on the matter we suggested you attend to, paragraph 1 applies if the government proceeds with the action. Paragraph 3 applies if the government elects not to proceed with the action. Paragraph 4 applies whether or not the government proceeds with the action. And paragraph 2? It is not like the others. Though granting the government important rights, including the right to dismissal over the relator's objection, paragraph 2 does not specify when it applies. And that is the mystery at this case's heart. With the game thus afoot, we turn to the facts, though there are only a few you need to know. Petitioner Jesse Polansky is a doctor who worked for Respondent Executive Health Resources, EHR, a company that helped hospitals bill the United States for Medicare-covered services. In 2012, Polansky filed, under seal, as required, a qui tam action against EHR. The complaint alleged that EHR was enabling its clients to cheat the government, essentially, by charging inpatient rates for what should have been outpatient services. After reviewing Polansky's evidence, the government declined to intervene during the seal period. The case then spent years in discovery, with EHR demanding both documents and deposition testimony from the government. As its discovery obligations mounted and weighty privilege issues emerged, the government assessed and reassessed whether the suit should go forward. By 2019, it had decided that the varied burdens of the suit outweighed its potential value. The government therefore filed a motion under subparagraph 2A to dismiss the action over Polansky's objection. The district court granted the request, finding that the government had thoroughly investigated the costs and benefits of allowing Polansky's case to proceed, and had come to a valid conclusion based on the results of its investigation. The Court of Appeals for the Third Circuit affirmed after considering two legal questions. First, does the government have authority to dismiss an action under subparagraph 2A if it declined to intervene during the seal period? The Court of Appeals held that the government has that power so long as it intervenes sometime later. And here, the Third Circuit found, the government had satisfied that condition because its motion to dismiss was reasonably construed to include a motion to intervene, which the district court had implicitly granted. Second, what standard should a district court use in ruling on a subparagraph 2A motion to dismiss? The Court of Appeals held that the proper standard comes from Federal Rule 41A, the rule governing voluntary dismissals in ordinary civil litigation. And here, the Third Circuit ruled, the district court's decision, which was based on a thorough examination of the interests that Rule 41 makes relevant, was not an abuse of discretion. Because both those questions have occasioned circuit splits, we granted certiorari. We now affirm the Third Circuit across the board. To show why the Third Circuit is right on the first question presented, about when the government can make what we'll call a 2A motion, we proceed in two stages, corresponding to two sets of arguments. None of the parties here agrees with the Third Circuit. On the one side, the government and EHR contend that a 2A motion is always permissible, even if the government has never intervened. Their argument is mainly one from silence, because paragraph 2 does not explicitly say when it applies. For example, when the government proceeds with the action or when it elects not to, provision must apply all the time. On the other side, Polansky, joined by the dissent, contends that the government can make a 2A motion only if it has intervened during the seal period. Polansky understands the dismissal power to arise only when the government assumes primary responsibility for the action, and he does not think that occurs. Rather, he thinks the relator remains in control if the government intervenes later on. To work our way through this thicket, we address first the government's and EHR's theory, then Polansky's, and the dissent's. We come out the other end in the same place as the Third Circuit. Paragraph 2, like paragraph 1, applies only if the government has intervened, but the timing of the intervention makes no difference. So the government can file a 2A motion to dismiss whenever, whether during the seal period or later, it has intervened. Even taken alone, paragraph 2 refutes the idea that it applies regardless of intervention. When the government has chosen not to intervene in a qui tam suit, it is, by definition, not a party, and non-parties typically cannot do much of anything in a lawsuit. To be sure, a qui tam action is an unusual creature. Even as a non-party, the government retains an interest in the suit and possesses specified rights. But paragraph 2, unlike other FCA provisions, does not say that it applies when the government is a non-party. So the government can prevail on its argument only by implication, and the implication does not fit. The paragraph's first two provisions grant the government uncommon, even extraordinary power to dismiss and settle an action over the objection of the person who brought it. That sort of authority would be odd to house in an entity that is taking no part in, indeed, has continually declined to join, a case. And still more conclusive, the paragraph's next two provisions presuppose that the government has in fact intervened. One provision enables the court to restrict the relator's role when needed, to prevent interference with the government's prosecution of the case, and another allows the court to restrict the relator's participation if the defendant would otherwise suffer an undue burden. The premise is again that the government has joined the case, else a court would be limiting the role of the defendant's sole adversary. Zoom out to the rest of the statute, and the government's intervention is irrelevant. View looks even weaker. Above paragraph 2 is paragraph 1, which begins and ends in telling ways. Recall that paragraph 1 starts by announcing that it applies only if the government proceeds with the action, something that, everyone agrees, cannot happen unless the government intervenes. In that event, the paragraph says, the government assumes primary responsibility for the suit. But still, the paragraph concludes, the relator may continue as a party, subject to the limitations set forth in paragraph 2. That last subjective phrase links paragraph 2 to paragraph 1. It says that when the paragraph 1 situation obtains, the relator's continuing role will be limited in the ways set out in paragraph 2. And once again, the paragraph 1 situation obtains only when the government has intervened. So that is also when paragraph 2's provisions, including the one about dismissal, kick in. In other words, the express intervention prerequisite of paragraph 1 carries forward into paragraph 2 through the subject to clause connecting the two. Only when paragraphs 3 and 4 are reached does the necessity of intervention drop away. Recall that they apply respectively when the government elects not to proceed and whether or not the government proceeds. By contrast, paragraph 2 is explicitly hooked to paragraph 1, which applies only when the government proceeds. And just to pile on a bit, the government's alternative construction would create surplusage twice over. Consider first the whether or not introductory clause of paragraph 4 noted just above. On the government's view, That clause has no function. A provision lacking it would likewise apply whether or not the government chose to intervene. The government essentially concedes the point, urging only that paragraph 4's preface is the sort of redundancy that is common in statutory drafting. Similarly, for the subject to paragraph 2 proviso in paragraph 1. On the government's view, Congress need not have included that language, because every qui tam action, not just those described in paragraph 1, is subject to paragraph 2's limits. Again, the government's only response is that Congress sometimes includes language that could be viewed as redundant. Yes, sometimes. But on top of everything else, the government's double violation of the interpretive principle that every clause and word of a statute should have meaning dooms the view that paragraph 2 applies even when the government has not intervened. The paragraph does not then apply, which means that the government cannot then file a 2A motion to dismiss. At the same time, a straightforward reading of the FCA refutes Polansky's and the dissent's position that paragraph 2, and also paragraph 1, applies only when the government's intervention occurs during the seal period. Recall the way the statute works: the government can intervene at that early time, but so too it can intervene at a later date upon a showing of good cause. The consequence of a successful motion to intervene, in the FCA context as in any other, is to turn the movement into a party. And once the government becomes a party, it, alongside the relator, does what parties do. It proceeds with the action. That quoted phrase, you'll recall, is the trigger for paragraph 1. When the government proceeds with the action, it assumes primary responsibility for the case's prosecution. And, as shown above, whenever that is true, paragraph 2 kicks in too. So the right to dismiss under subparagraph 2A attends a later intervention, just as it does an earlier one. Either way, the government becomes a party, proceeding with the action. So either way, it acquires the right to dismiss. Polansky's contrary argument, echoed in the dissent, mainly relies on the clause in paragraph 3 telling the court that it may not limit the status and rights of the relator when it approves a post-seal period intervention motion. That clause, he says, prevents the court from giving the government primary responsibility over the suit, including the power to dismiss. But on that reading, the paragraph 3 clause would effectively negate paragraphs 1 and 2. The paragraph 3 clause would prevent the government, even though now proceeding with the case, from acquiring the control that paragraphs 1 and 2 afford in that circumstance. Polansky's construction would thus put the statute at war with itself. The statute would direct one result: the government assuming the primary role upon intervening, while telling the court not to allow that state of affairs. The better reading makes the instruction to the court congruent with the background operation of the statute. The clause tells the court not to impose additional, extra statutory limits on the relator when granting the government's post-seal period motion to intervene. In that way, paragraph 3 ensures that the government will get no special benefit from the court's involvement in a later intervention. The parties will occupy the same positions as they would have if the government had intervened in the seal period. That seal-agnostic view of intervention's effects also fits the FCA's government-centered purposes. In Polansky's proposed world, the government has primary control of the action if it intervenes in the seal period, but the relator has primary control if the intervention occurs later on. But in both cases, the government's interest in the suit is the same and is the predominant one. That interest is typically to redress injuries against the government through a suit brought in the government's name. Or else, as here, that interest is to obtain dismissal of the suit because it will likely cost the government more than it is worth. Either way, that interest does not diminish in importance because the government waited to intervene. Congress decided not to make seal period intervention an on-off switch. It knew that circumstances could change and new information come to light. So Congress enabled the government, in the protection of its own interests, to reassess qui tam actions and change its mind. When it does so, nothing about the statute's objectives suggests that the government should have to take a back seat to its co-party relator. The suit remains, as it was in the seal period, one to vindicate the government's interests. We thus arrive at this case's second question. When the government, having properly intervened, seeks to dismiss an FCA action over a relator's objection, what standard should a district court use to assess the motion? The Third Circuit held that the appropriate standard derives from Federal Rule 41A, which governs voluntary dismissals in ordinary civil litigation. Under that rule, the standard varies with the case's procedural posture. If the defendant has not yet served an answer or summary judgment motion, the plaintiff need only file a notice of dismissal. But once that threshold has been crossed, as in this case, dismissal requires a court order, on terms that the court considers proper. Again, both the government and Polansky object from different directions. The government thinks it is essentially unfettered discretion to dismiss. Polansky proposes a complicated form of arbitrary and capricious review, with a burden-shifting component. But again, the Third Circuit's Goldilocks position is the legally right one. A district court should assess a 2A motion to dismiss using Rule 41 standards. And in most FCA cases, as the Court of Appeals suggested, those standards will be readily satisfied. The reason for alighting on Rule 41 is not complicated. the federal rules are the default rules in civil litigation, and nothing warrants a departure from them here. As Rule 1 states, these rules govern the procedure in all civil actions and proceedings in the United States District Courts, with specified exceptions not relevant here. Of course, Congress may override that command when it wishes, but we do not lightly infer that Congress has done so, and silence on the subject is seldom enough. Here, nothing in the FCA suggests that Congress meant to accept qui tam actions from the usual voluntary dismissal rule. To the contrary, the FCA's many cross-references to the rules suggest that their application is the norm, and this court has made clear that various rules not specifically mentioned, in particular those dealing with discovery, also apply. As a practical matter, the federal rules apply in FCA litigation in courts across the country every day. There is no reason to make an exception for the one about voluntary dismissals. The application of Rule 41 in the FCA context will differ in two ways from the norm. The first pertains to procedure. The FCA requires notice and an opportunity for a hearing before a subparagraph 2A dismissal can take place, so the district court must use that procedural framework to apply Rule 41 standards. The second pertains to the set of interests the court should consider in ruling on a post-answer motion. In non-FCA cases, Rule 41A 2's proper terms analysis focuses on the defendant's interests. The court mainly addresses whether that party's commitment of time and money militates against dismissal. But in the FCA context, the proper terms assessment is more likely to involve the relator. For all relators faced with a 2A motion want their actions to go forward, and many have by then committed substantial resources. Part of the district court's task is to consider their interests. The Third Circuit, though, was right to note that 2A motions will satisfy Rule 41 in all but the most exceptional cases. This court has never set out a grand theory of what that rule requires, and we will not do so here. The inquiry is necessarily contextual, and in this context, the government's views are entitled to substantial deference. A qui tam suit, as we have explained, is on behalf of and in the name of the government. The suit alleges injury to the government alone, and the government, once it has intervened, assumes primary responsibility for the action. Given all that, a district court should think several times over before denying a motion to dismiss. If the government offers a reasonable argument for why the burdens of continued litigation outweigh its benefits, the court should grant the motion, and that is so even if the relator presents a credible assessment to the contrary. In light of those principles, this case is not a close call. A district court's Rule 41 order is generally reviewable under an abuse of discretion standard, and the Third Circuit properly applied that standard here. But in the interest of providing guidance, it might be useful for us to put that standard of review to the side, and simply to say that the district court got this one right. The government, in moving to dismiss, enumerated the significant costs of future discovery in the suit, including the possible disclosure of privileged documents. At the same time, the government explained in detail why it had come to believe that the suit had little chance of success on the merits. Polansky vigorously disputed the latter point, claiming that the government was leaving billions of dollars of potential recovery on the table. But that competing assessment, the district court thought, could not outweigh the government's reasonable view of the suit's costs and benefits. We agree. The government gave good grounds for thinking that this suit would not do what all qui tam actions are supposed to do: vindicate the government's interests. Absent some extraordinary circumstance, that sort of showing is all that is needed for the government to prevail on a 2A motion to dismiss. The government may move to dismiss an FCA action under subparagraph 2A whenever it has intervened, whether during the seal period or later on. The applicable standards for deciding such a motion are those set out in Federal Rule 41. Under that rule, the government was entitled to dismiss this qui tam action. We therefore affirm in all respects the judgment below. It is so ordered. Justice Kavanaugh, with whom Justice Barrett joins, concurring. I join the court's opinion in full. I add only that I agree with Justice Thomas that there are substantial arguments that the qui tam device is inconsistent with Article 2, and that private relators may not represent the interests of the United States in litigation. In my view, the court should consider the competing arguments on the Article 2 issue in an appropriate case. Justice Thomas, dissenting. In my view, the text and structure of the False Claims Act, FCA, afford the government no power to unilaterally dismiss a pending qui tam action after it has declined to take over the action from the relator at its outset. Thus, I would vacate the judgment below and remand for the Third Circuit to consider the serious constitutional questions that may affect the disposition of the government's motion to dismiss petitioner's qui tam suit. Because the court instead affirms, I respectfully dissent. The FCA provides that private parties known as relators may bring qui tam suits for themselves and for the United States government. It then sets out a reticulated scheme to govern the initiation of a qui tam suit, the parties' procedural rights during the suit, and the rights of the parties to any proceeds at the end of the suit. The main structural feature of this scheme is the so-called seal period, a window of time at the start of every FCA qui tam action during which the suit is on hold, and the government must elect whether to intervene and proceed with the action, or, alternatively, to decline to take over the action and allow the relator to proceed. This case requires us to decide whether the government enjoys the same panoply of procedural rights when it takes over an action during the seal period and when, as here, it intervenes in the action at a later date after the relator has proceeded with the action. Today, the court holds that the government has all of the same procedural rights in both circumstances, including the right to dismiss the action notwithstanding the objections of the relator. I would instead hold that the structure of the FCA's qui tam provisions and the clear text of Section 3730C(3) do not permit the government to seize the reins from the relator to unilaterally dismiss the suit after declining to proceed with an action during the seal period. To bring out the statutory structure, it is helpful to take the FCA's qui tam provisions from the top. Under Section 3730B(2), the first step in a qui tam suit is for the relator to file the complaint in camera and under seal, serving it on the government but not the defendant. That filing starts the clock on a 60-day window in which the government may elect to intervene and proceed with the action. The government may move to extend this seal period for cause, but ultimately the government faces a binary choice. It must either A. Proceed with the action, in which case the action shall be conducted by the government, or B. Notify the court that it declines to take over the action, in which case the relator shall have the right to conduct the action. Thus, under Section 3730B(4), the government's seal period choice to proceed with the action or not determines who shall conduct the suit, the government or the relator. Section 3730C picks up at this critical juncture, defining the respective litigating rights of the government and the relator based on the government's choice to proceed with the action or not. First, paragraph 1 of subsection C provides, if the government proceeds with the action, it shall have the primary responsibility for prosecuting the action, but the relator shall have the right to continue as a party to the action, subject to paragraph C2's limitations. As used here, the phrase proceeds with the action naturally refers to the same seal period choice for which Section 3730 uses the same phrase in paragraph B2 and subparagraph B4a, and the government having the primary responsibility for prosecuting the action appears synonymous with the government conducting the action under subparagraph B4a. By contrast, paragraph C3 provides, if the government elects not to proceed with the action, the relator shall have the right to conduct the action. The conditional clause of this sentence is a clear reference to the seal period election described in paragraph B2. Likewise, the result clause plainly echoes the right to conduct the action referred to under subparagraph B4b, which the relator requires when the government does not proceed with the action under subparagraph B4a at the end of the seal period. In short, the initial clauses of paragraphs C1 and C3 track subparagraphs B4a and B4b and point back to the government's seal period choice to proceed with the action or not. If the government chooses to proceed with the action under Section 3730B(4a), then paragraph C1 applies, along with the conditions of paragraph C2. Conversely, if the government elects not to proceed with the action under Section 3730B(4b), then paragraph C3 applies. To be sure, the last sentence of paragraph C3 provides, when the relator proceeds with the action, the court, without limiting the status and rights of the relator, may nevertheless permit the government to intervene at a later date upon a showing of good cause. But this sentence is not, as the majority reads it, a secret pass in paragraph C3 that leads the parties back to their relative rights under paragraphs C1 and C2. The sentence itself makes that clear by cautioning that the government's later intervention may not limit the status and rights of the relator. Read in the context of sections 3730B, 4, and C, without limiting condition clearly preserves the relator's status as an autonomous litigant, and the right to conduct the action that he acquired when the government declined to take over the action at its inception. In other words, the plain import of the condition is that the relator keeps the right to conduct the action under sections 3730B, 4b, and C3, as opposed to being demoted to paragraph C1's inferior right to continue as a party with the restrictions set out in paragraph C2. The majority short-circuits this straightforward conclusion by essentially stipulating that the government proceeds with the action and thus activates paragraphs C1 and C2 whenever it is a party, regardless of when and how it became a party. Nothing in the FCA's overall text or structure favors that interpretation, nor does the text of paragraph C3, When that provision describes the government intervening after the seal period, it does not use the phrase proceed with the action, except in reference to the relator, nor is the majority's understanding compelled by the ordinary meaning of the term proceed. To proceed means to move forward, generally with the distinctive connotation of moving forward from a particular point. That idea fits the FCA like a glove. The government proceeds with the action as that phrase is used in sections 3730b, 2, B4A, C1, and C3 if it chooses to move forward with an action from the seal period, which is specifically set up for the government to decide whether to proceed with the action, section 3730b, 2. The majority's interpretation of proceeds with the action in turn dictates an unnatural reading of paragraph C3s without limiting condition. When the FCA says that the government's belated intervention may not limit the relator's status and rights, it naturally means the status and rights that the relator actually enjoyed under paragraph C3, immediately before the government sought to intervene. By contrast, to accommodate its misreading of proceeds with the action, the majority is compelled to read paragraph C3 to protect only the status and rights that the relator would have enjoyed in an alternative timeline where the government intervened during the seal period and paragraph C3 never came into play at all. That reading is counterintuitive, to say the least. Nor is that the end of the problems with the majority's seal-agnostic view. Immediately below subsection C, sections 3730d, 1, and d2, establish two alternative ranges for the relator's share of any recovery at the end of a key TAM action. Like the party's litigation rights under paragraphs C1 and C3, those ranges depend on whether the government has proceeded with the action or not. If the government proceeds with an action brought under subsection B, the relator is usually entitled to between 15 and 25% of any recovery. Conversely, if the government does not proceed with the action, the relator is entitled to 25 to 30%. Given the majority's view that intervention under paragraph C3 counts as proceeding with the action, it follows that even an 11th-hour intervention by the government would automatically shunt the relator out of paragraph D2's more generous range and into paragraph D1's less generous one. Surely, that result would qualify as limiting the relator's status and rights. The majority bolsters its tenuous textual and structural case with an appeal to the FCA's government-centered purposes. But every statute purposes, not only to achieve certain ends, but also to achieve them by particular means. And, while it is certainly the FCA's ultimate goal to redress injuries against the government, its chosen means is to empower private parties to seek redress of those injuries through litigation that the government does not necessarily control, and might not have brought if left to its own devices. Allowing the relator to maintain the suit after the government has declined its initial opportunity to take it over, even if only to dismiss it, is fully consistent with the FCA. Indeed, the FCA's history undermines the majority's free-floating account of its purposes. As enacted in 1863, the original FCA contained no provision for the government to intervene in a relator's suit at all. In 1943, Congress first gave the government that opportunity by creating the 60-day seal period, which it set up to function as the very on-off switch the majority seems to consider implausible. Either the government intervened during the seal period and assumed sole control of the action, or it did not intervene and was permanently excluded from the action. Finally, in 1986, Congress revamped the FCA into its modern form, under which, as never before, the government and the relator can litigate side by side as co-plaintiffs in the same action. In creating this possibility, Congress tweaked both halves of the previous regime in roughly parallel ways. If the government intervenes during the seal period, paragraphs C1 and C2 now permit the relator to remain a party and play a role in the litigation, but only a subordinate role. Conversely, if the government does not intervene and proceed with the action during the seal period, it is not forever barred from taking a litigating role, but, if it intervenes later, it does not downgrade the relator's status and rights to those of a second-chair litigant. Section 3730, C3. In sum, the text, structure, and history of the FCA all point to the same conclusion. The FCA affords the government no statutory right to unilaterally dismiss a declined action when it intervenes under Section 3730C3. However, the text and structure of the FCA are not the end of the story. Defendant-respondent has pointed to serious constitutional questions that might affect the disposition of the government's motion here. At the same time, it is not clear that the parties have examined these questions in their full complexity, and the Third Circuit's reading of Section 3730C gave it no reason to do so. Therefore, after holding that the government could not invoke the dismissal authority of Section 3730C, 2A, as a statutory matter, I would remand this case for the Third Circuit to consider whether the Constitution nonetheless requires the dismissal of petitioner's suit. The FCA's key TAM provisions have long inhabited something of a constitutional twilight zone. there are substantial arguments that the qui tam device is inconsistent with Article 2, and that private relators may not represent the interests of the United States in litigation. Because the entire executive power belongs to the President alone, it can only be exercised by the President and those acting under him. And, as a lawsuit is the ultimate remedy for a breach of the law, the Court has held that conducting civil litigation for vindicating public rights of the United States is an executive function that may be discharged only by persons who are officers of the United States under the Appointments Clause. A private relator under the FCA, however, is not appointed as an officer of the United States under Article 2. It thus appears to follow that Congress cannot authorize a private relator to wield executive authority to represent the United States' interests in civil litigation. The potential inconsistency of qui tam suits with Article 2 has been noticed for decades. The primary counterargument has emphasized the long historical pedigree of qui tam suits, including the fact that the first Congress passed a handful of qui tam statutes. Standing alone, however, historical patterns cannot justify contemporary violations of constitutional guarantees, even when the practice in question covers our entire national existence and indeed predates it. Nor is enactment by the first Congress a guarantee of a statute's constitutionality. Finally, we should be especially careful not to overread the early history of federal qui tam statutes, given that the Constitution's creation of a separate executive branch co-equal to the legislature was a structural departure from the English system of parliamentary supremacy, from which many legal practices like qui tam were inherited. In short, there is good reason to suspect that Article 2 does not permit private relators to represent the United States' interests in FCA suits. However, even if that is true, the follow-on implications may not be as straightforward as they appear at first glance. Under the FCA, the relator brings suit for himself as well as for the United States government. In Stevens, we read this language as affecting a partial assignment of the government's damages claim, which provided the theoretical justification for our holding that a qui tam relator under the FCA has Article 3 standing. For that holding to make sense, it appears that this assignment must be effective no later than the point in time at which the government declines to intervene in the seal period, and the relator may proceed with the action as the only plaintiff in court. Under Stevens' partial assignment theory, it is not immediately clear that the government may dismiss the relator's interest in a qui tam suit, even assuming that the relator's representation of the United States' interest is unconstitutional. Whether the government may do so may depend on the implicit conditions of the assignment. Conceivably, it may also depend on whether the assignment is severable from the FCA's attempt to vest the authority to represent the United States in litigation in a party outside the executive branch. In examining these issues, moreover, it may be necessary to consider a question that Stevens left unaddressed: what is the source of Congress' power to effect partial assignments of the United States damages claims? One candidate might be the necessary and proper clause, but if qui tam suits violate Article 2, then it appears unlikely that any assignment effectuated by the FCA's qui tam provisions could be considered necessary and proper for carrying into execution any constitutional power. Alternatively, such assignments might rely at least partly on the property clause, which empowers Congress to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and which may include the power to assign claims for damages as other property. In any event, these are complex questions, which I would leave for the parties and the court below to consider after resolving the statutory issues that have been the focus of this case up to now. Therefore, I would vacate the judgment below granting the government's motion to dismiss and remand for the Third Circuit to consider the correct disposition of that motion in light of any applicable constitutional requirements. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.